Good morning and welcome to the forum at All Souls Unitarian Universalist Church. My name is Evelyn Maddox and I'm proud to represent the All Souls Forum Committee, whose core group of dedicated people developed the program schedule for Sunday mornings. Our forum, which has been operating since 1943, provides a platform for the discussion of significant issues in our contemporary world. Our routine is to have the speaker present for about 35 minutes. We then pause to take up a collection and to announce the next week's topic. Our speaker's pause is followed by a Q&A period of about 20 minutes, which will take us to adjournment at 10:30. This program is recorded for airing on KKFI radio at noon on Thursdays. It is being live streamed on YouTube today, where viewers may post their questions to the chat. We monitor the questions in the chat to ask the speaker during the Q&A. For those of you in the audience, please make your cell phones quiet and hold your questions until the Q&A period if you're in the room here at the forum. I'm now pleased to introduce this morning's speaker, Denise Lieberman, who is speaking to us from St. Louis. I have known Denise for about 8 years in her capacity as the director of the Missouri Voter Protection Coalition. Her willingness to take on tough legal challenges is legendary in Missouri. She is here today because of her work as the plaintiff's attorney for the Reverend Tracy Blackman v. State of Missouri lawsuit, which challenges Missouri's abortion ban and abortion restrictions. The lawsuit argues that the Missouri's restrictions establish one religious view about abortion as the law of the land in violation of the Missouri Constitution's robust protections for separation of church and state. By the way, excuse me, she represents a plaintiff clergy from Episcopalian, Orthodox Judaism, United Church of Christ, Reformed Judaism, United Methodist, and Unitarian Universalist traditions. She is currently faculty director of the Voter Access and Engagement Initiative at Washington University in St. Louis, where she is adjunct professor of law and political science. She is a nationally recognized voting rights lawyer who has been on the front lines of voting rights debates in Missouri and around the country for the last 20 years. For the past 15 years, she has been director and general counsel of the Missouri Voter Protection Coalition, which has over 150 community partners whose nonpartisan efforts protect the voting rights of Missourians. She has brought lawsuits on voter ID laws, early voting requirements, and rights restoration in states like Missouri, North Carolina, Louisiana, Wisconsin, Florida, and others. It's obvious to everyone that Denise has the experience and expertise to take on the state of Missouri to protect our right to choose our reproductive health care. So now, Denise, please tell us what you have to say today.
Thank you so much, Evelyn. It's such a pleasure to be here with all of you at All Souls Church and really appreciate the attention that your church gives to issues of public importance, issues of social justice. I recall that we have done voting rights programs and election protection trainings at your church, and I think it speaks so highly to the importance that your faith places on advancing social justice. And for people of faith, this should come as no surprise. Many people of faith and many faith uh, um, uh, organizations prioritize ensuring access to equal services, freedom, and basic human dignity of all people. And that's a core tenet of many faiths. And that's really what brings us here today. My name is Denise Lieberman, and I am honored to serve as local counsel on behalf of Americans United for Separation of Church and State and the National Women's Law Center in bringing a lawsuit in Missouri challenging Missouri's abortion restrictions and abortion bans as a violation of the separation of church and state. The first lawsuit of its kind in the country. And I'm here today to tell you a little bit about how that case came to be and why the separation of church and state is so critically important to ensure robust religious freedom and equal rights for all. I'm going to share my slides now. Well, the story here in Missouri actually starts long before last year's Supreme Court decision that overturned 50 years of precedent guaranteeing women the right to make decisions about their bodies in healthcare. In fact, our lawsuit begins well back into the early 80s when Missouri began passing a series of restrictive abortion legislation. However, that legislation was, while allowed to be in effect, some of that legislation could not be used to actually ban access to abortion because the Roe v. Wade precedent was on the books. For example, Missouri law, literally chapter 1 of the Missouri statutes, states that life begins at conception and that all Missouri laws should be interpreted to give full personhood status to embryos and fetuses, just like people who are living, breathing, and walking in our communities. But that wasn't allowed to be used prior to the Dobbs decision to expressly ban access to abortion because of the Roe v. Wade precedent, which guaranteed a fundamental right to make healthcare decisions about one's own body pre-viability. Now, we all recollect that day last year on June 22nd when the United States Supreme Court issued its ruling in the Dobbs decision, overturning Roe v. Wade, overturning 50 years of precedent, guaranteeing the rights of women to make personal healthcare decisions for themselves. And this, of course, impacted millions of Americans. By overturning Roe v. Wade, what the Supreme Court did was say there is no fundamental right that Roe v. Wade had previously established. There's no guarantee that the government needs to have an exceptionally important reason to restrict access to abortion. And there was no right in the United States Constitution for women and their medical providers to make those decisions for themselves. That meant that those determinations fell back to the states and that state laws and state constitutions would now rule the day. Obviously, millions of people were affected. An estimated 24 million women of reproductive age live in areas where the distance to the nearest abortion clinic would increase by at least 100 miles. Think about that, right? So think about states like Missouri that immediately put a trigger law into place, creating an immediate ban on virtually all abortions in the state of Missouri. And while access was already pretty bad, there was only one abortion clinic in the entire state of Missouri. Now there are 0. And women in Missouri will have to travel perhaps to Illinois or to Kansas or to another state that allows access to this fundamental health care. in order to access it. So here's the landscape in Missouri and why Missouri was really looked at as the key place to bring this lawsuit. First, Missouri was the very first state to enact a trigger ban after the Dobbs decision overruling Roe and Casey. And Missouri already is a place that has, even before the downfall of Roe, access to abortion was extremely limited in the state of Missouri. Public taxpayer dollars in Missouri have increasingly been used to fund crisis pregnancy centers that don't provide any medical support, provide false information. Nearly $9 million in last year's state budget went to these clinics, and even more proposed this year. Because of the lack of access in Missouri, which also had on the books a 72-hour waiting period before somebody could get an abortion, meaning they had to meet with a physician, wait 72 hours before they could have the procedure, and it had to be the same physician. Again, with only one abortion clinic in the entire state of Missouri, that made access nearly impossible for many residents of our state. We also had regulations on hospital privileges for doctors that shuttered the last remaining abortion clinics in the western side of the state and in mid-Missouri. And because of all these barriers to access, Missouri was already Missouri was a state that had one of the highest maternal mortality rates, not just in the country, but in the world. And on top of that, women of color were at even greater risk. The racial disparity in the state of Missouri on maternal mortality is also one of the highest in the nation. Black birthing parents' risk of death from childbirth is 3 to 4 times higher than their white birthing counterparts. Carrying a fetus to term, carrying a baby to term is far more dangerous, particularly for women of color, than terminating a pregnancy. And so here's the landscape across the country. While Missouri, and you can see on the left side of my slide here, there's a tweet from Governor Mike Parson proudly announcing that Missouri was the very first state to end abortion after the Supreme Court ruling in the Dobbs decision overturning Roe v. Wade. He writes, in response to today's SCOTUS ruling overturning Roe v. Wade, I've signed a proclamation activating the Right to Life of the Unborn Child Act, ending all elective abortions in the state. And I want to say it's more than simply elective abortions. Missouri's ban makes no exception for rape, no exception for incest, no exception for health conditions of the mother, much less any exception for other medical considerations that she and her doctor may be discussing, and no exceptions for any socioeconomic concerns or the person's desire not to have a child. The other thing that's important to know is that the majority of people who get abortions already have children. The majority of people who get abortions, in fact, it's the vast majority of people who get abortions already have children. And either they have health issues or they believe that it is not something that they can take on. But at the end of the day, it doesn't matter. It shouldn't matter. The state should not be inserting itself into the role of making that decision for the pregnant person and her doctor. And you can see on my map here that this affected not just Missouri, although Missouri was the first, that there were a number of states, more than a dozen states, that had trigger bans already in place that automated an abortion ban from going into place. Then, as a result of the Dobbs decision, other states on top of that began passing or changing existing laws to ban abortion. And so you can see here that in the central part of the country is really a healthcare desert where access to healthcare for pregnant people is going to be available on the East Coast and the West Coast, but barely anywhere in between. And breaking it down further, we can see right now the places where abortion is fully banned. And that includes many, not only Missouri, but of course, many of the states surrounding Missouri. That brings us to this lawsuit. On January 19th of this year, 13 faith leaders representing an array of denominations across the state of Missouri brought a lawsuit challenging Missouri's abortion restrictions as a violation of the separation of church and state. Now, you might think this is sort of an odd way to think about an abortion ban. You might think, well, hasn't the court looked at the right to abortion as a fundamental right to bodily integrity? And yeah, that was the basis on which the court in Roe v. Wade determined that the right was fundamental, that there was a fundamental right to substantive due process under the 14th Amendment that guaranteed a right to liberty, a liberty that included the right of women to make personal decisions about their bodies and about their health care. Or you might think that this is about equality under the law, that women's lives and women's bodies are regulated in ways that men's lives and men's bodies are not. That women's lives and women's bodies in Missouri are regulated in a way that they're not regulated in California. And you would be correct on that too. Because the Supreme Court's ruling reversed the understanding that the right to control your body and your reproductive health care is a fundamental right. It no longer has that power of law. The other reason that this was looked at in this way is because when you look at the history of abortion laws around the country, you look at the way that abortion laws are being implemented right now, but in particular, if you look at its history in the state of Missouri, what you will see on its face, as well as when you dig in to under the covers, that Missouri's abortion laws are unambiguously religious in nature, that they are rooted in one concept of religion to the exclusion of others. Missouri was selected to be the first state, both because Missouri's law is so blatantly religious on its face as to leave no question that lawmakers were imposing a singular religious viewpoint on everybody else. The second reason Missouri was selected as the first state to bring this kind of a case in the country is because, and this might surprise you, Missouri's Constitution contains even stronger protections for the separation of church and state than the United States Constitution does. And so while you might think that a state like Missouri is not a likely one to be on the front lines of expanding abortion access and bringing back the right to health care, indeed we are. So I'm going to tell you a little more about this case. Here's actually what the lawsuit, the first page of the lawsuit looks like. has filed. And we filed it on January 19th because it was right before that weekend's 50-year anniversary of the Roe v. Wade decision on January 22nd. And I'm going to show you a short video before we get into the rest of this.
Today, we are challenging Missouri's abortion ban. Because we know that America needs a national commitment to church-state separation. Let's start right here with Missouri. You cannot impose your beliefs on us or use your place beliefs as narrative.
Abortion is healthcare. We are united to protect the freedom of religion of all people. Our freedom to live out our faith or profess no faith at all is an inalienable right.
These faith leaders said it better than I could ever say it myself. And for each of them, their reason for being part of this lawsuit is because they argued that as people of faith, as people who care deeply about faith, that faith has no place in government decisions about our bodies and about our health care. And each of these individuals stepped up because they believe that Missouri's abortion legislation is rooted in faith precepts that don't mirror their religious beliefs and that don't mirror the religious beliefs of many, many people in the state. And they realize because they are people of faith, how important it is that they be allowed to exercise their faith freely. And that when Missouri passes laws that are rooted in one faith belief over another, it threatens the rights of all of us to exercise our faith freely. The truth is, my friends, the separation of church and state is the critical wall that keeps us free, that allows us to believe as we want to believe, to worship as we wish to worship. The day we filed this lawsuit, the faith leaders and their supporters walked down to the courthouse. And this is a picture of the St. Louis City Circuit Court where we filed this lawsuit. And I was very proud to serve, and I am proud to serve as local counsel and the person that filed the suit on their behalf. And we had a rally downtown at a local church, a very beautiful place to really be able to uplift the power of faith and the power of the church, but also to establish its critical role in our society. Here are some of the incredible faith leaders that you see here and here. They represent a wide array of religious traditions. And so I want to share with you just a little bit about some of these individuals. Hang on a second. Oopsie, I do want to pull that back up. We have members of the Unitarian Church, Episcopalian Church. We have Reform Jewish leaders. We have Orthodox Jewish leaders. We have a range of individuals from across the state of Missouri, including several in Kansas City, as you know, Reverend McKissick and Rabbi Doug Albert. I want to share a little bit about them briefly. Reverend Tracy Blackman is the lead plaintiff in this case. She is the Associate General Minister of Justice and Local Church Ministries for the United Church of Christ. And she believes, and she's spoken at rallies for abortion justice in the past, and believes the importance of church-state separation because it offends her religious freedom by legislating one narrow view of Christian principles, where the United Church of Christ has worked to fight for liberation of marginalized people and explicitly supports reproductive justice. Reverend Blackman is part of this case because she believes that theology can also be used to oppress. And that's what she believes these challenge provisions do. Our second plaintiff is Reverend Barbara Pfeiffer, who is a United Methodist minister and also a state representative. And so as somebody who's both in government and in the church, she understands the separation between church and state. And she was raised a Southern Baptist. But she herself experienced a miscarriage, a missed abortion, a miscarriage where the fetus remains in the uterus, and had some difficulties and understands because of her experience that the access to healthcare is so critically important. She ultimately received a D&C, but she could have died without necessary medical care. One of her beliefs has to do with a Methodist methodology that employs 4 sources to arrive at theological conclusions: scripture, tradition, reason, experience. And so she uses guiding force, scripture as a guiding force, but does not believe that it should be followed literally. And again, as a state legislator, she understands the critical role that lawmakers play should not interfere with religion. Another plaintiff is Maharat Rory Picker-Nice, who is the executive director of the Jewish Community Relations Council. And she was ordained in the modern Orthodox Jewish church, a Jewish synagogue. And she believes that that Judaism recognizes that you can't make broad statements about pregnancy. The Jewish faith recognizes the health of pregnant people and prioritizes the health of the pregnant woman over the health of the fetus. Jewish law is clear that the fetus is not given the same value or status as that of the living person until such time as it's taken its first breath outside of the womb. We also have Molly Hush Gordon, who's in Boone County and a minister at the Unitarian Universalist Church in Columbia, who believes that abortion can be life-saving. We have the Right Reverend Bishop Dean K. Johnson, the 11th Bishop of the Episcopal Diocese of Missouri. We have Reverend Holly McKissick, who's a founding pastor, Peace Church United Church of Christ in Kansas City. The Reverend Krista Tavis, who is a minister of congregational life at Elliott Unitarian Chapel. The Reverend Cindy Bum, who is an ordained minister at the United Church of Christ. Rabbi Susan Talvey, the founding rabbi of Central Reformed Congregation in St. Louis. Who states that Talmud in Jewish law concluded that the life of the mother always takes precedence over the fetus, teaching, quote, if a woman who is having trouble giving birth, her life comes before its life. And this is supported by Reform and conservative branches of Judaism. Rabbi Doug Albert is the rabbi of Congregation Kol Ami in Kansas City. And he speaks about the principle, Pekuach Nefesh, that saving a human life takes precedence over any other commandment in Jewish law. Given the risks of pregnancy, he believes this principle requires access to abortion. Reverend Janice Barnes is with the United Church of Christ in the First Congregational Church, Webster Groves. Rabbi Andrea Goldstein and Rabbi James Bennett are with Congregation Sheremet in St. Louis. And Reverend Darrell Gray, who is with the Progressive Baptist State Convention. All of these individuals are speaking their truths about the role of religion from a deeply religious perspective. Now, let me share with you what's going on and what's being challenged in this case, because it's not just Missouri's trigger ban. This case is also challenging the 72-hour mandatory delay that was passed in 2014. The same physician requirement, which I mentioned, where you have to speak with the same physician in between those 72-hour days. Here in Missouri, before the fall of Roe v. Wade, there was only one physician that was performing abortions at the Planned Parenthood clinic, who often came in from Kansas City. To be able to speak to that person twice in 3 days was nearly impossible. There are also restrictions on medication abortions. And of course, the trigger ban, which was passed in 2019, House Bill 126, which creates complete ban on abortion, except in medical emergencies, which is not well defined. Basically, it means that the woman's life has to be in danger. And that was passed in 2019, even though Roe was still on the books, but it included this trigger ban that said as soon as Roe v. Wade falls, the Attorney General can sign this into law. And he waited about 4 minutes, I believe, before signing Missouri's ban into law after the Dobbs decision came down. There's also a cascading series of abortion bans beginning at 8 weeks, 14 weeks, 18 weeks, and 20 weeks that are part of this law. And there's also a ban on abortion for various reasons. For example, if the child has Down syndrome, it also bans selective abortion based on sex. These are serious, serious crimes. A violation of House Bill 126 is a Class B felony, punishable by 5 to 15 years in prison. But there is hope. And while the United States Supreme Court has rejected that there is a fundamental right of liberty to control your body, state constitutions now rule the day because the decision has been moved back to the state. And guess what? Missouri has a strong wall of separation of church and state. In 3 provisions of our state constitution, Article 1, Sections 5, 6, and 7, prohibit the establishment of a particular faith. And these are more protective than the federal constitution. Our constitution says that no human authority can control or interfere with the rights of conscience. That neither the state or its subdivisions can establish any official religion, and the state cannot coerce any person to participate in any religious activity. Section 6 prohibits the state from compelling any person to support any system of worship or maintain or support any sect, church, creed, or religious denomination. And importantly, no state money can be used to advance religion, nor can any discrimination against religion occur. And those 3 things are exactly what is happening here in the state of Missouri, rooted in the very first chapter of our state laws, that our state policies must be viewed under the belief that the life begins at conception, and that Almighty God is the author of life. This is the actual language of Missouri's House Bill 126. It states, again, this is not somebody quoting, this is the actual language of the law itself, that it is the intention of the General Assembly to regulate abortion in recognition that Almighty God is the author of life, and that life begins at conception. Hang on a second. I have now lost my other slide. Hang on. Here we go. And so now I want you to check this out. Because not only does the language of the statute itself make very clear that one religious viewpoint is behind this, take a listen here to what lawmakers who sponsored this law said.
Life begins at conception. Psalms 119 says, your hands made me and formed me.
Being from the biblical side of it, I've always believed that life does occur at the point of conception.
As a Catholic, I do believe life begins at conception. That is built into our legislative findings currently in law.
Someone had mentioned yesterday that this is unconstitutional separation of church and state. Well, the fact of the matter is, I know of no greater way of affirming the natural rights of man than to declare that they are a gift from our Creator.
God doesn't give us a choice in this area. He is the creator of life. And I, being made in his image and likeness, don't get to choose to take that away, no matter how that child came to be.
And what makes you valuable is that you equally share the image of our Creator. You are his work of art.
To me, life begins at conception. My God doesn't give that option.
You have inherent dignity protected by the Constitution and inherent dignity provided by God.
I rise to offer an amendment ending in .18H. It has been distributed. I move for its adoption.
The only question I have is a rhetorical one, and that is, how many of our constituents agree with the statement that God is the author of human life? That statement itself is in violation of the separation of church and state. It's an anti-constitutional statement in and of itself, and I ask the body to oppose the amendment.
Excuse me, Denise, this is Evelyn, but this seems to be a good time to take a pause because I can see people in the room gasping. So, Denise, with your permission, we'll just pause and we'll resume after taking a collection. Thank you.
I think that's perfect timing. I think it really lays out precisely why this case is so important. Thank you so much.
Yes. Listener contributions, both in person and online, to be made either today or later, go to paying the costs of not only promoting forum programs, but also for the staff time to make sure presenters have what they need for their best presentation. There are also costs to provide tech support to make sure we reach as wide an audience as possible. We urge you, everyone here in the room and at home, to consider joining others who have become monthly supporters of the forum by setting up an automatic contribution for All Souls. There are instructions in a chat posting about how to set up an automatic contribution to All Souls. While we are collecting donations, we'll announce that next week's topic will be an update on Kansas City's local food and farming scene. Kyla Gross, manager of the Brookside Market, and Alicia Ellingsworth, who is executive director of the KC Farm School, will describe the multitude of opportunities to obtain locally and regionally produced food in the Kansas City area. And they'll talk about ongoing efforts to grow a community food system. Now, I do have to remind you in the room, please, if you are here in person, come to the mic to ask your question when we resume with Q&A. Do speak clearly into the microphone and face the television screen so viewers at home and the speaker can see you speaking. Remember, online or in person, one question per person until everyone has had an opportunity to ask a question. But please, no speeches. You may have something very interesting to say, but would rather hear what the speaker has to say in response to your question. So we're reminding those at home, please put your question in the chat and we'll read it for everyone to hear. Now, Denise, do you have more to say or are you ready for questions at this time?
I think we can go right into questions at this time. I think that video really spelled out, um, what this case is about. I do have some thoughts on calls to action that we can include in the Q&A.
Well, we'll certainly look forward to hearing about the calls to action. We are an action-oriented group, and we do have someone in the room ready with a question.
Thank you for that wonderful presentation. You touched on this a little bit with the sexism, but to what extent do you think belief in traditional gender roles has a lot of men and even a few women in society thinking that they shouldn't have the right to make a choice about abortion?
Thank you for your question. And certainly there are a lot of dynamics that go into the history of our nations in our states abortion restrictions, and certainly they are historically rooted in notions of traditional gender roles, and as were early contraception laws as well, right? Because the thought was that if women had the ability to control their bodies, that they might not need men. Um, in a, and I say that sort of very kind of, it can't be, but that really is the history of many of these laws. You didn't see these restrictions. The truth is that birthing people have been terminating pregnancies as long as there have been people able to give birth. And the question, and that's not going to stop now either. The question is whether women have the autonomy to make that decision on their own. The question is whether they have the right to access it safely, or whether they have to do so secretly in ways that are dangerous to themselves and their families. And I mentioned that the vast majority of people who have abortions already are mothers, are parents, and being pregnant adds additional health risks. And lacking access to safe abortion doesn't mean that it's going to go away. It means that it's going to be less safe. And I think that historically, what you see is that fear of women's autonomy has been part of this story from the get-go. You can start to see the enforcement of laws regulating contraception and abortion until the women's suffrage movement began gaining a lot of steam in the latter part of the 19th century. And that's when you first began to see things like publications that talked about access to contraception being labeled as obscene materials. And so, yes, misogyny is rooted, and our notions about the role of women are deeply rooted in these decisions. And so even those lawmakers who were quoting scripture as the basis for their support, I would suggest to you, we're still impacted by misogyny and our society's misogyny towards women in doing so.
Thank you, Denise, for such an interesting presentation. I took a look at the case, and I wonder if you might speak a little bit more about the Unitarian Universalist minister in Boone County's additional claim. I know she has a different position and an additional claim based on her own reproductive rights, and I think that's pretty interesting.
Thank you. Thank you. Yeah, I appreciate your point. So these folks are, you might wonder, well, how are faith leaders able to bring this case? You saw lots of folks that were beyond childbearing age and individuals who are unable to bear children, personally affected. And argument in this case is that they're affected because this offends their faith. And they're affected because they're taxpayers. And we have something called taxpayer standing in Missouri, meaning that if tax dollars are being used to fund something that is unconstitutional, as a taxpayer, you've got standing to say, hey, my tax dollars can't be used for unconstitutional purposes. And so that actually is the basis on which they are plaintiffs in this case. However, there are several plaintiffs of childbearing age who have the ability to bear children, and at least one that has had has had significant health care concerns in the past, and has had has had healthcare concerns with pregnancy in her past, and would need to have access to this healthcare should such a pregnancy come up again. And so not only is her complaint related to not having her taxpayer dollars being used for unconstitutional purposes, but also it's that her own right to get access to needed health care is on the line. And Missouri's ban by not having any exceptions for rape, for incest, or for even generalized health conditions. The only exception is medical emergency, that many folks are saying really means that you have to be on the verge of death before an intervention can be made, meaning that people who have, for example, ectopic pregnancies may be forced to carry, where the fetus dies inside of you, could be forced to carry that dead fetus inside of them, even though that presents a risk, serious health risk to the person carrying it. So these folks are in this not just because of their faith, but also in some cases because they too could be denied health care under this ban.
Thank you so much for clarifying that. I have a question about putting together the lawsuit, the whole range of reproductive justice, including both the right to abortion, the right to bear children, and the right to raise children in a safe and secure environment, really presents such a wide array of possibilities. So I'm assuming that more narrowly tailoring this particular case will probably allow the blossoming when it succeeds of these other reproductive justice issues.
Wow, that is that's really astute of you to say that. And yeah, you're absolutely right. Many of the faith leaders that we spoke to spoke holistically about the full range of those rights when describing their desire and interest to be part of this lawsuit. And of course, your right to your own medical care, to make your own medical decisions with your medical provider, with your to be counseled by your faith leader of choice, is so deeply rooted in our own rights of personal autonomy, as are our rights to have children and to ensure that they are safe and healthy. And I suppose the irony on some of this is that while our state sits here on the guise of advancing godliness to deny women access to health care, while cutting back funding for our schools, while denying Medicaid expansion, denying us access to health care, while criminalizing our gender nonconforming children, really belies that underlying intent involved in this case. And I think our faith leaders are such powerful spokespeople for this idea. So many of these faith leaders spoke about the importance of lifting the totality of each individual and their right to live and their right to thrive. And that is what their faith demands. And so it really, I think, showcases the hypocrisy of our lawmakers who claim to be acting on the word of God, but refusing to provide or ensure that people are able to thrive in our society.
Thank you.
Hello, Denise. Thank you so much for all of your work on this. It's been a tremendous amount of work, I think, organizing all these people. And I want to thank you for coming today to the forum to present to us. We really appreciate it. My question has to do with, I've been a long supporter of Americans United for separation of church and state. I think they do wonderful work. And I'm curious about how this work is being replicated in other states and at the federal level as well. So if you could comment on that.
Yeah, that's a great question. And I will say this, it was a lot of work to put this together, because, when you're bringing a lawsuit that has never been brought before, you want to make sure you do it right. And, Missouri is not normally the kind of place that folks look to be to be a trendsetter, to push the envelope. And so this lawsuit was months and months in the making, really immediately after Roe fell. Our partners at the National Women's Law Center and at Americans United began talking with their partners around the country. And this lawsuit came together because advocates across the state of Missouri all got on board, that they all began sharing information, and included in this, we've got now 14 plaintiffs, but there are literally hundreds of advocates who came together to bring this case and to identify and really think deeply, with deep conscience, about why this was a problem. Missouri was good choice for the first one because the language of our law was so explicitly religious, and our lawmakers were so unambiguously religious in citing their basis for bringing for these laws, and that our state constitution, it provides stronger protection for the separation of church and state. But now other states that have similarly religious based laws, also have stronger constitutional provisions, are looking to follow Missouri's lead. I think this is a really a good, and no other lawsuits have been filed yet, but I am aware that other states that have stronger constitutional protections are looking to do so. So I can't say precisely when those things are going to happen, but I know that they are. And at the meantime, at the federal level, I think this is really hard. And unless Congress passes some legislation that would provide protections, which have been proposed, I don't think that we are going to see support at the federal level. In fact, it could be dissipating. The problem is that the same floor of protections that guaranteed that right of bodily autonomy was recognized in Roe v. Wade are the same. It's the same constitutional provision that guarantees access to contraception, that guarantees the right to love whoever you want to love, that guarantees access to same-sex marriage, that guarantees access to a range of personal decisions and personal autonomy. With that right being stripped away, it does open the door. And Justice Clarence Thomas noted this in his opinion in the Dobbs case. All of these other rights are potentially on the line. So it really speaks to the importance of us being eternally vigilant. But I want to say finally as well, and I see that we have another question here, the role of faith communities is critical, because too often we politicize this issue, and it doesn't need to be politicized. When faith leaders can uplift the critical importance of recognizing the basic human dignity of all people, we can persevere and we can succeed. And so I think the role of churches and the role you are all playing right now is absolutely critical in ensuring that this conversation pivots to the impact on real people and recognizing the rights of all people to live free and dignified lives.
Thank you very much, Denise. I hope you can give us a very short answer to my last question, which is that it seems recently, at least, the Missouri Supreme Court ruled that state funds could be given as a grant to a church to be used for the purchase of playground padding. Do you think that Supreme Court decision will in any way affect your lawsuit, since it did rule that state funds could go to the church for the special covering on the playground?
Right, but
Yes.
funds to a playground, those sorts of things can be allowed even if a religious institution is sponsoring it if the purpose is not religious. So that's one
Okay.
big difference between that and here. The purpose of a playground isn't to advance one religious view over another, even if that playground is located in a church. Whereas Missouri's Constitution makes clear that no funds can be used to advance a particular faith belief or faith tradition. Missouri's abortion law explicitly advances one particularized religious viewpoint, religious faith, and religious tradition over others. And that's a really big difference. That's a difference that matters here.
All right. Well, thank you so much for being with us. I know there is a lot yet to be said about this case and about the issue at large. And Denise has agreed to spend more time with us by staying online. And those in the room can adjourn to the library for further discussion with Denise now. We do thank you so much, Denise, for being here. We want to know that everybody is invited to stay for the service, which begins at 10:45. It'll be streamed online for those who care to join it at 10:45. So we thank everyone for attending the forum, and we'll see you next week. Okay. So stay online, Denise.